So what I'm going to present to you today is research that I've been doing for the past few months. This paper is actually coming out relatively soon in Transnational Environmental Law, which is a leading journal in environmental law. But my background in this is I specialize in financial regulation, and prior to this paper, I wrote another paper looking at the obligations of the European Central Bank to promote environmental protection. So this paper that you see today is an expansion of that earlier work. And what I've done in this paper is I've tried to map out the different types of litigation that can arise in financial markets related to climate change. So what you have here is a table that shows all the different types, all the different climate cases worldwide in all the different sectors. So far we have slightly more than 1,000 climate cases in 25 jurisdictions. And this is data that has been compiled by Carbon Delta using two databases, one that is based at Columbia Law School in New York and another one that is coordinated by the Grantham Research Institute in the London School of Economics. So what I've tried to do is to dig how many of those cases have taken place in financial markets or in relation to financial transactions. And this is a summary of the different cases that meet that criteria, okay? And out of the 1,000 plus cases that we've had across all different sectors, I have identified 46 cases in the financial services industry. Now, this may seem like a relatively small number, but I think there are issues that we need to consider when looking about further research that may explain these low numbers. But what I think is very interesting is that in line with the tendency that we see in climate litigation more generally, in financial markets, we're also seeing a considerable increase in climate litigation. And what I'm hoping to do today is to convince you that when we're trying to understand how to promote sustainable finance, when we're trying to understand what we can do to change the way finance is done, we need to take litigation and we need to take law into consideration. So a few additional data. This is a breakdown of the cases by jurisdiction. So as you can see, most of the cases have been filed in the United States, and this is understandable given the culture of litigation in the United States. But also we have a considerable number of cases having been filed in Australia, up here, sorry, and in the UK, okay? And as you can see, I think it's almost 90% of the cases that have been reported have been filed in these three jurisdictions. And there are interesting questions around these geographical bias that I will touch upon towards the end of the presentation. A few points on methodology. As I said, these cases have been sourced from these two databases that are the main databases that collect climate cases around the world. I focus on financial services and transactions rather than on financial participants. So we can be looking at cases that involve non-financial participants, but that involves the issuance of equity securities, for example. The typology that I have designed to try to identify the different types of climate cases in finance responds to a claims-based approach. So what I'm trying to understand is what would plaintiffs in these cases argue against the defendants, typically issuers or financiers. As I said before, my hope today is to convince you that litigation matters for changing finance, okay? And I think there are four broad reasons why people in this conference should be thinking about litigation and the impact that it has on sustainable finance. The most evident reason is that litigation can have an effect on governance, okay? We can see litigation as a governance mechanism. We have examples, mostly when I talk about climate cases, examples of cases being filed against governments. The most representative one, maybe one that people have heard about, the Urgenda case against the Dutch government. And we see more and more actors trying to use the courts to shape and influence the behavior of market participants, including governments. So we can see litigation as an effective tool, or potentially effective tool, in the governance of climate change. The second important reason is that litigation can have a considerable effect on the implementation of policies or the conclusion of financial transactions. I will mention one example from monetary policy later on, but just to give you an idea that litigation can thwart the effectiveness of the policies that are being designed or the financial transactions that are being developed in markets. There can be reputational costs arising from litigation, and perhaps the tricky bit about litigation is that you don't need to get a court decision for your reputation to be affected. The mere fact of a case being filed against you, or your client being put on notice that is going to be sued before the courts, can have significant effects on the reputation of that client. And lastly, if there is if that trend on climate litigation continues to grow, that can have a considerable effect on compliance costs and legal costs that banks and other actors in the financial services face that can erode their profits. So these are the different types of cases that I have identified in financial markets, and rather than talking through each of them in detail, I will give you a few seconds just to read the different categories, and then I will move on to talk about the ones that I think are more relevant for us in the conference. Okay, so one of the most common types of claims in climate cases in the financial services industry is a claim related to disclosure. And in the paper, I identified two different types of cases that relate to primary market disclosure obligations. There's an interesting precedent here. In 2017, Kinder Morgan issued an IPO, and Cynthia may have some insights from this. So Kinder Morgan issued an IPO. Greenpeace Canada challenged the information that was being disclosed in the prospectus, and then I think it was the Alberta Securities Commission asked Kinder Morgan to amend the prospectus and include information relating to the impact that climate change was going to have on the potential returns of the securities that were being issued. So we have precedents, relatively recent precedents, where NGOs in this case have been able to influence the issuance of securities in primary markets. In secondary markets, there was an interesting case filed only a few months ago in the United States where the Advocate General in New York is suing ExxonMobil on fraud allegations because they claim that ExxonMobil knew that the price of their securities was inflated and yet did not disclose that to its investors, to the securities holders. That litigation is still ongoing, but I think it evidences the type of risk that these firms face when it comes to climate litigation in relation to financial assets or financial transactions. One of the things that people working in sustainable finance are probably hopeful about is the TCFD, the Task Force on Climate. I can never get this right, but you know what I mean, the disclosure of non-financial risks related to climate change. So I think this, what we see in the litigation sphere is that the TCFD, as one of the most advanced initiatives, at least one of the industry initiatives, is likely to open the door to a lot of litigation in the future. We have seen some cases relating to disclosure up to today, but we're likely to see many more coming up just because of the degree of implementation that we're seeing with the TCFD. And this is going to have implications for other aspects like fiduciary duties, which have come up over the course of today's presentations. The second most important type of claim is one that is based on decision-making processes. These typically involve environmental impact assessments. We have cases where public authorities, public financing authorities like development banks, for example, have faced litigation because they were not complying with legal requirements to undertake environmental impact assessments. We also have precedents of claimants suing public authorities for not giving them the opportunity to have a say on the process. Okay, so this is telling us that the process that these public finance authorities follow when extending finance, for example, in some of their operations, matters a lot, because claimants who consider that the rights have been violated may use litigation to thwart the whole process. We have examples of decision-making processes affecting or litigation based on these claims against public authorities and also against private institutions. I don't have details about one case in particular that relates to private institutions, but just to give you some anecdotal evidence, last year in 2018, I believe, one of the biggest Chinese banks was faced an administrative penalty because they had failed to comply with what Chinese regulation calls green due diligence. Okay, so the bank had failed to do some checks on the environmental impact that the projects that they were financing were going to have, and the regulators the supervisors imposed a fine eventually last year. So we have examples of jurisdictions imposing procedural requirements on banks and other financial institutions in relation to environmental due diligence. One interesting thing about decision-making processes, I think, is that they can be, at least in my opinion, effective in informing upcoming regulation. We can talk a little bit more about that in the Q&A, but I think trying to influence the decision-making process of both public and private institutions is likely to have a great impact if we want to change the way business is done in the financial services industry. I'm not going to talk too much about fiduciary duties, partly because it's a hugely complex topic and we would probably need several hours to cover it. But just to give you an idea of what's happening, there tend to be two positions when we come to interpret what is the scope of fiduciary duties. And the division between these two is more on the time horizon than on the nature of the interpretation. So the two main positions agree that, to some extent, the best interests of clients means the financial interests of clients, okay? But there are two different positions on what is the time horizon when we talk about best interests. So some people say, well, this is a short-term interest. If we invest in green assets, that is going to undermine the financial returns. The other position is, well, we have to take a very long-term perspective. And if we look at the long-term perspective, financial interests of our clients are directly linked to the development of climate change. So there is a split when it comes to the time horizon, okay? And the time horizon is interesting because what we've seen so far in the context of climate litigation is that the market participants that are facing the highest risk of being litigated against are pension funds. And pension funds are particularly vulnerable to climate litigation risk precisely because they have this longer term horizon. It is more likely that as a manager in a pension fund, you may be in breach of your fiduciary duties if you're not taking into consideration climate change effects on your portfolio because your mandate goes or spans a longer term horizon than, say, another type of mutual fund. Okay, I've got 5 minutes left, so I'll go very quickly over the last two categories. Authorities or mandates are an interesting category because they expose the vulnerability of financial regulators and supervisors. If supervisors take a proactive approach, and as some people mentioned in the previous panel, for example, when we talk about central banks engaging in green monetary policy, if central banks try to go too far beyond their mandate, they are going to be exposed to a considerable litigation risk. And the example of the European Central Bank in the Eurozone, with many investors challenging some of the measures, unconventional measures of monetary policy, is a good example. But equally, if market participants consider that supervisors and regulators are not doing enough, if sustainability is within their mandate, these supervisors and regulators may also face the risk of litigation. So for regulators and supervisors, it's very difficult to find and to strike a balance that will steer you away from the risk of litigation. Lastly, and very briefly, I'd like to talk about fundamental rights because I think it's a it's a category that people normally associate with cases where NGOs, private individuals, bring cases before the courts arguing that the activities of other actors, the defendants, undermine their fundamental rights, those fundamental rights typically being the right to a healthy environment, the right to enjoy, the right to family, the right to privacy, different types of fundamental rights that have an individual dimension. That's the key idea. But what is interesting when one looks at litigation in financial services more broadly, not just restrained to the specific context of climate, is that we have precedents where investors in financial institutions and creditors of these financial institutions that have been affected by decisions from financial regulators or supervisors are suing these regulators and supervisors on fundamental rights. Okay? So what we've seen, for example, in the context of bank resolution is that creditors that are wiped out if a bank is put into resolution are suing the regulator, arguing that the right to property has been undermined, that the right to legitimate expectations has been undermined. And just to give you an example, 2 years ago, Banco Popular, one of the largest Spanish banks, the largest bank in the EU to have been put into resolution under the new rules, was put into resolution in 2017, and then we have more than 50 cases before the Court of Justice of the European Union from investors and creditors affected by that decision from the ECB, arguing that the rights to private property and legitimate expectations have been undermined. So all of this is just to signal that fundamental rights may also be used as a sword of sorts by investors and creditors who see their positions affected by regulatory decisions related to climate change. Let me conclude with some reflections about the many questions that I think this preliminary research opens, because one of my motivations to being here at this conference is that I hope that new opportunities for interdisciplinary research will arise. And I think that climate litigation is very prone to that kind of research. And let me share with you some of my ideas about how that might be, how that might unravel. One of the things that the map, it's not really a map, but this paper is trying to identify the different types of litigation, okay? The legend in a map, if you want. But I think from my conversations with law firms in the City of London and some NGOs in the UK, this is what everyone is trying to get. Everyone is trying to understand what that map looks like. And in order to draw that map of where litigation in financial markets might arise, we need to understand a lot of different things. So we need to understand what are the merits of these claims, what types of remedies are the parties going to seek, are there any procedural barriers to filing these cases, etc., etc. You might remember the graphic from the beginning where mostly 90% of the cases have been filed in 3 jurisdictions, the UK, the US, and Australia. One of the reasons for that may be that the databases that we have at the moment seem to have a geographical bias towards English-speaking jurisdictions. So there's a huge question about what's happening in China and Japan. Another important question is, what is the role of courts in the governance of financial markets in particular? We have some literature on the role of courts in the governance of climate change more broadly, but there isn't that much literature on the role of courts in the governance of finance. And lastly, and I think this is really the opportunity for interdisciplinary research, we don't know yet what is the economic impact of this type of litigation on the performance of financial services firms. So I think this is probably one of the best opportunities for economists, sociologists, and lawyers to engage in interdisciplinary research. And my time has run out, so I'll leave it there.